I understand your colloquy with the Chief Justice and Justice Thomas. You do accept that in aid of can't mean a shot in the dark,
Yes.
right?
Yes.
There has to be some causal link, some close connection of some kind between the liability and the IRS's actions.
I
Between
wouldn't
the
say
request for information and the IRS's actions.
I would not say close connection.
Some connection.
Some connection.
And so so what we're really fighting about, everyone agrees in aid of can't mean the universe.
Yes.
And it's just how closely connected it has to be. That's what the debate is really about.
I don't disagree with that, and I would say two things about why we think that the limits should be broader than
Sure, but we don't disagree on principle that an aid of has to have some limit to it. We're just disagreeing over, and I just want to clarify, the nature of our dispute is how close that causal connection has to be. Does it matter whether your co-counsel went to Yale, or does it matter what he did last night? You know,
Right.
somewhere in between is
Yes.
what we're fighting about.
I do agree with that. We don't think in-aid can be limitless. This is an exception to a default rule, and also we think...
And do you think that informs our analysis, that the default rule is notice, and so that when we're construing an exception to that, we should do so reasonably, in light of the general rule?
Reasonably, but not narrowly. I mean, you're...
Reasonably.
Yeah,
You agree with that?
Yes.
Okay.
Reasonably, fairly, yes.
Okay, thank you.
And I guess the two things I was going to say about the phrase in aid of and why we think the limit should be broader than they suggest are, number one, I think in aid of is fairly broad general language. I don't think I read that as a narrowing phrase like petitioners do. I don't think that's how it's naturally understood.
Do you think the government could have done what Justice Thomas posited, and that is say, well, you know, this law firm has lots of clients, some of whom might have come into contact with the petitioner here and might be aware of his assets, and so we want information about all of their transactions too.
Based on those facts alone, I don't think so.
Well, isn't that what you did here, though? Because you sought 2 years' worth of records from the firm without regard to its clients. I mean, with no sensitivity to the attorney-client privilege of those clients or their interests.
So I'd like to clarify that, because on page 21A, this is the Court of Appeals opinion. The Court of Appeals said that the limitation in this summons is borne out, that the summonses the IRS issued to the banks in this case all specify that they seek information concerning the person identified in the summons. So the way that we read the summonses and the way that the Court of Appeals read them is that they were asking for information from the bank about the law firm's bank statements, and other stuff could have been redacted.
Okay.
So
there is a limit to in aid of in your mind right there. You don't think the government could seek other information about other clients, or do you?
No. Well, the way we would talk about the limit is the point here is to locate the delinquent taxpayer's assets.
I understand that.
So the third party should have some financial ties or has engaged in financial transactions with the delinquent taxpayer. Otherwise, the point is not to locate the delinquent taxpayer's assets. So that's how we would articulate it.
Well, John may know Susie, who may know Joe, who may know Mr. Polselli. But you'd say that at some level that becomes too attenuated.
At some level, but here the summonses were quite close in connection.